How about now?
There we go.
Excellent. Okay. So, um, today it's about the rules, regulations, and directives governing drug use in the clearance process. So again, what have we been talking about? We've talked about um, where you can work, the broad overview of the clearance process. We dove into that SF-86. I'm going to be pulling excerpts out again today. Uh, and talk in detail about some of the regulations dealing with the clearance process and drug use. Again, a reminder, a lot of people have properly use the Q&A. Feel free to type questions in the Q&A. Again, this is one that tends to get lots of questions. What about this situation? What about that situation? Again, even if you ask about a specific situation, I am not a lawyer. I'm not giving legal advice. Virginia Tech is not giving legal advice. If you need legal advice, see a lawyer, a real expert. More especially as I'm going to talk a little bit about the status of drug use in a particular state at a particular time. That's always changing. Don't say Professor Berger said it was okay as you're being arrested, right? That's not going to work for you. So the thing to take away, if you fall asleep for the rest of the next 50 minutes, the law is explicit. If you're using, you lose. You cannot get a clearance if you're using illegal drugs. Now, if you have used, then as we keep talking about, like bankruptcy, arrest records, all that, it's going to be facts and circumstances. So it's not I used, therefore I can't, or I used, I should be able. It's going to depend on your facts and circumstances, as well as what position you're applying for. I will, towards the end, go through sort of the policies of some various agencies you might be interested in working at. You will hear this over and over and over again. Do not lie on the SF-86 or at your interview. That is worse and a separate infraction. For the most part, you won't be prosecuted for what you admit on your SF-86. But if you lie, if you admit, then it's going to be bad things for you. And the key for today's talk is the federal law might be different than state law. Your clearance is a federal thing, not a state thing. So in case if I don't say it enough, really be truthful. And you might notice if you can see it in the small font, the questions pertain to illegal use of drugs, even though permissible under state law. So the highlighted thing, this is, what's coming out there. Your truthful responses or information derived from your responses to this section will be used as evidence against you in a subsequent criminal proceeding. So even though drug use may be federally illegal, if you say, yeah, 35 years ago in college, I smoked marijuana. On the one hand, you're admitting to a federal crime. They're not going to prosecute you for it. If you don't say it and it comes out, fair game. So this is the status that I am aware of as of April 1st. This is different. If you look at the archive for last year, there were some states that had that D for decriminalized that have now moved into that blue, legal for recreational use. And so, various states have allowed the consumption and manufacturing of cannabis products. It's decriminalized in that kind of upper tier you see there. In the green, legal for medical use. With the D, it's decriminalized. So, in Nebraska, you see it's not legal, but basically that's not what they're going to arrest you for. Although they might up something if you're, caught doing something bad. And typically decriminalize, if you have small amounts, they're not going to prosecute you, or it might be a modest fine, a misdemeanor, or something like that. So today's news, this is an article from today's Wall Street Journal that the administration, federal president, looks to reclassify marijuana as something that's a less dangerous drug. So basically today, marijuana is considered the same as heroin or acid. And basically the administration is saying, hey, we want to reclassify it. So again, looking at the states, this is how the states view cannabis use. Well, even with this announcement, this is how the federal government treats cannabis. It's illegal everywhere. It is still, until this administration, if they can do it, reclassify it, it's still a Schedule 1 drug, which means legally, and we don't want to talk about medical here because it's really just the law that matters. Legally, it's a drug that has a high potential for abuse. Legally, it has no accepted medical use and treatment in the United States, even though we've seen that medical marijuana is legal in many states, and that there's a lack of accepted safety for use, even under medical supervision, even though many states allow it. In fact, in Virginia, before it was made more broadly available, only veterans were allowed to have medical marijuana. So yes, put that in your head, kind of contradictory. Yep, it's contradictory. And that's the way the law is, that right now it's still a Schedule 1 drug. And the discussion is not to make it generally available, but to change the schedule, which I'll talk about in a minute. So right now, today, what does it mean for something to be a Schedule 1 drug? It means it's unlawful to manufacture, distribute, dispense, or possess. So again, simple possession is illegal, or to possess with an intent to manufacture, distribute, or dispense a controlled substance. So you basically can't have it. So what does this mean in practice? If you have a clearance and you use, you're going to be in a heap of trouble. That's very clear. So now let's say you're applying for a clearance and you are using and you declare it. You're currently violating federal law. I can't imagine whether that you would get a clearance. Maybe you could try, but I can't imagine it. Now let's take the next scenario. You're applying for a clearance and you had used. So you do declare, because you don't want to lie. You may be cleared, facts and circumstance. And that's really one of the things they're really looking at is what is the likelihood that you're going to continue using marijuana? One of the questions is, what about Puerto Rico? And the answer is that is a U.S. Territory, possession, protectorate. It's considered part of the federal orbit. So yes, Puerto Rico is covered by this. So even though my understanding is marijuana is legal in Puerto Rico, if you say, well, I used in Puerto Rico, so it shouldn't count, the answer is no, it still counts. I can't say it enough times, don't forget to declare. Now, something to note is some of the questions say, have you in the past 10 years? And my recollection is drug use is one of those have you in the past 10 years. So if it was 10 years and a month, don't waste their time. Answer no. If it was 9 years, 11 months, and 28 days, answer yes. And say, by the way, it was almost 10 years ago. But you definitely don't want to lie. Some of the questions are, have you ever? Answer truthfully. Because if you don't answer truthfully, you won't get cleared and you may be prosecuted. So let's look at what the Director of National Intelligence says. Remember from the last session, the DNI sets the policy for clearances and the whole national security infrastructure. So again, and this is where I got it from, you can't be using today, full stop. If you did use it in the past, then the DNI says facts and circumstances. Did you try it once and didn't like it? Were you, did you have to get checked into a hospital to detox? Was it yesterday or was it 30 years ago? And, is it likely to recur again? Yeah, I partied with my friends. That was 5 years ago in college. I graduated. I haven't seen them. Don't expect to see them. Low chance of recurring. Or yeah, my whole family are dealers and I like partying with them on Memorial Day. That's going to be a problem. He revisits manufacturing and distribution. The answer pretty much is no. And then CBD, cannabinol derived products. So, CBD is hemp. It's technically not marijuana, but we do get this yes, but no situation. The first is legally, CBD is not technically cannabis if it contains less than 0.3% of THC. One issue is there's very little oversight of CBD products. So they are notorious for being mislabeled. And by the way, even if it's like 0.1% THC, if you fail a drug test and you don't smoke, you don't eat gummies, you don't eat brownies, but if you take CBD and you fail the drug test, basically the OPM and DNI guidance is you fail the drug test. I don't know if it's still up, but like at Federal Triangle and Smithsonian Stop and the I forget the other large federal campus down south on Independence Ave. There were posters up in the metro saying, "Hey, be careful about using CBD products because if you take them and you fail, you failed." So let's say you don't smoke, you don't grow. Growing is manufacturing. So having that little pot plant in a pot on your windowsill is manufacturing marijuana, manufacturing a Schedule I substance, violating federal law, and you're not a dealer. So, hey, I don't do any of that, and I'm keeping away from CBD. Well, remember that manufacturing is actually pretty broad. And so there is a clarification. In fact, some of the companies mentioned in today's Wall Street Journal article are publicly traded companies. They're, on the New York Stock Exchange, on the NASDAQ. So, hey, can't I buy stock? I'm buying stock. It's like I'm buying stock in Raytheon, like I'm buying stock in Google. And the DNI has clarified that basically that makes you a partial owner of a company that makes something that is illegal on the federal level. And so that is a thing to be aware of. Now, there is the usual exemption, and again, I'm not giving legal advice here, but the usual exemption is like if you have a like an all index mutual fund, you can't not have that stock in it because it's part of the all index. So you're not saying, I want to buy that stock. Now, if you buy the marijuana growers exchange traded fund, that might be problematic. But if it's a passive investment and it's a de minimis amount, that's generally okay. Now, again, the focus has been on marijuana, principally because of this confusion. In fact, now in Virginia, but it's legal in my state, but it's not legal at the federal level. Just a reminder, we're not talking only about marijuana. Again, this is from today's article. The reason why I pulled it from the article and not the DEA website is the DEA lists all like 6,700 controlled substances, but these are kind of the top ones that give you an idea of the different levels of the scheduling. So for example, heroin, LSD, ecstasy, and for now, marijuana are examples of Schedule 1 drugs, whereas cocaine, fentanyl, methamphetamine, oxycontin, well, which is oxycodone, are Schedule 2 drugs. And this actually comes right into a question that came up in the Q&A. Oxycodone is still prescribed today. And so if you get a prescription for oxycodone and you take the oxycodone, you're okay. You have the prescription. If you have some extras and go, I really like the spaced out feeling I got towards the end of when I needed it. I'm going to take some more. You're abusing the drug. And so in a sense, even though you had a prescription for it, a legal use does count against you. Now, mind you, if you are a pilot, if you are a truck driver, if you're taking oxycodone, you are legally intoxicated. So you're flying while intoxicated, driving while intoxicated. That's violating the law. So this is not a blank check. But they are actually looking, I believe they're looking to make it a Schedule 3 drug, it being marijuana. So what would that mean? It would mean probably if you have a prescription, it'll probably be okay. That'll all depend on what the job is, what else happens around it, and your use. Similar thing, what about epinephrine? Uh, if you're making meth, even though it's over and over the counter, you turn it into something that's quite illegal. It's quite illegal. I did get a question, what about medications for ADHD or anxiety or any depression? We did talk about that a bit on, filling out your SF-86. Generally, the guidance will be, if you're using the medication as prescribed, and you've declared it, then it's probably okay. Now, mind you, let's say it's an antipsychotic. You might still not get your clearance because there might be a concern that you'll have a psychotic episode, and you might not be trusted with keeping the secrets of the United States. And another question is, what about foods that mimic drugs, like poppy seed bagels? And if you're not aware, that one may show up as like a heroin uh, use. And the answer really does come back to this is a place where you're going to have to prove yourself innocent, and you might not get the opportunity to prove yourself innocent. And basically, uh, the precedent is too bad for you. So, these are things to, have in your mind as you're thinking of, do I want a clearance? Do I want a job that, might put some of these constraints on me? There's another good question here that I'm going to get back to. So let's go back here. So what happens if you did use? Now, one thing that, again, check with a real lawyer on this one, because it's going to be brand new territory. Remember, one of the characteristics here is the question is not, well, actually, the question is, are you a drug user, right? Because if you are a drug user, what's the underlying reason why you're using drugs? And, is that a cause for concern? And generally, the government has said that alone is a cause for concern. But let's take, two things, one that's legal right now, one that's not: alcohol and marijuana use. Remember, they do ask, do you have a problem with alcohol abuse? They don't say, do you drink? They ask, is there a problem? Marijuana will probably end up in that category. So one thing they're looking for is, do you have personal issues that might become a concern for being able to keep national security secrets. But there's another thing that the government is looking for. Again, if you remember in the first webinar, we talked about how the government is trying to determine if you're trustworthy. And so the issue here is, even if effective today, marijuana becomes a Schedule III drug, it's not Schedule I, it's not as draconian, and you used marijuana yesterday when it was still a Schedule I. Well, one thing you've demonstrated is your willingness to violate federal law. And so that is part of the facts and circumstances, especially if you're in, say, Texas, where marijuana has never been, well, never is not right, because it was probably grown in Texas legally about 120 years ago. But today, it's very illegal in Texas. So, you're basically saying, I'm willing to violate state law and federal law. That might bring your trustworthiness into question. What other laws are you going to choose to not follow, even if right now it looks like marijuana use really isn't a Schedule I kind of thing. So keep that in mind. So let's look at, different agencies' perspective on if you had used marijuana. So the Secret Service, one thing that's an absolute, if you've used in the last year, easy no. Again, even if it's legal in your jurisdiction, like the District of Columbia, it's a no. What about recreational manufacturing? You grew a plant on your windowsill for your own consumption. You didn't even share it with your spouse. That's manufacturing. So they're going to look at, well, did you grow one pot of pot for yourself, Or did you have a garden that you were out, selling on the street corner? And in fact, if it was selling on the street corner, that's going to be one of those, have you in the last 10 years? If you sold your crop 9 years ago, Secret Service is going to say no. And then anything outside of those parameters, it's a no-go. And again, the TLDR on the other considerations is facts and circumstances. Let's look at another agency, the CIA. Again, 1 year minimum. If you used in the past year, hard no. And then the TLDR, facts and circumstances, and what they're looking for is, can you have a security clearance? And as you can imagine, everyone at CIA has one. So if you can't get a security clearance, you're not going to get a job. What about the FBI? So one is, again, past 12, you think you're seeing a trend here. Past 10 months, absolute no. What if you just turned 18? Well, if you used before then, they're looking at the whole person. It's not, so if you're 18 and a half and you used when you were 17 and 3/4, then that's not necessarily going to count. The FBI is kind of interesting. They do allow medical THC, but there's literally, and this may have changed in the past year, but as of now, there's literally only one prescription formulation that they would consider to not be a disqualification. Now, they're a little bit more nuanced, the FBI. So what about the other Schedule 1s? Well, even the Schedule 3s, if you used MDMA in the past 5 years, hard no. Prescription drugs, again, you got the prescription for oxycodone and you misused it, that's a no. You abused inhalants, so it's not a scheduled drug. In the last 3 years, no. If you're a bodybuilder, anabolic steroids without a prescription, you've done it in the past 10 years, it's probably going to be a no. And then for the FBI, a little bit different there. If you grew a pot in a pot for yourself, even if it's legal where you did it, that's a hard no for them. And maybe this is one I did pick it because of the starkness. The DEA, dudes, you're enforcing the drug laws. So if you were involved in drugs, but again, arrest or conviction. So you actually don't necessarily need a conviction. Even the arrest will put you under the microscope. Mandatory disqualification. Likewise, if you lie, mandatory disqualification. Now here, if it's like, if you say you experimented, so you weren't arrested, you weren't convicted, you did put it on your SF-86, and again, I would encourage you to put the facts and circumstances around down on it. Here they say you may be disqualified. They don't say you will be. But again, if you don't disclose, you're talking to the Drug Enforcement Agency. ATF, also kind of nuanced. If you were addicted pretty much to anything in the last 5 years, mandatory disqualification. Well, what are they looking at? They don't want to have the Washington Post writing an article about how their newest agent just got arrested for driving under the influence of marijuana. And it turns out that, yeah, you were, in a treatment program or something like that. Again, if you're doing distribution, sale, or transporting a controlled substance, this is the ATF. Same thing, manufacturing. Just as if you were manufacturing explosives illegally, you're probably not going to get a job with ATF. Same thing for drugs. CBP, kind of an interesting one. Uh, so like with marijuana, they buck the trend. It's not the 1 year, it's actually 90 days. Note though, that's for employment. You still are likely to get hit. You know, if you smoked 6 months ago, you're still likely to get hit with not being able to get a clearance until that year has gone by. They also do call out anabolic steroids and prescription drug misuse. Now that's 2 years. And the same thing for other drugs on the schedule, that would be 3 years. So now I'll actually, I'll hold off. Just a reminder, oops, just a reminder of the sessions coming up. We're going to talk and do again a deeper dive on the authorities, laws, and regulations in our June session. And pardon the pun, we will take a hit on how the SEEDS, those security directives, relate to marijuana and CBD. Where do these rules come from? And then probably one of the more relevant, besides this one always tends to get a lot of questions. But another one that tends to get a lot of questions is social media. What to consider in a virtual world. Again, looking at what the regulations are, what the best practices are, also things to protect you and your family, irrespective of the clearance process. So with that, I will go to the questions. Let me pull them up. I've got one here. So the question is, what if you're in a relationship with someone who has or is using pot or other drugs? I would have to look at the SF-86 because there may be a family question. And generally, family includes significant others. So if the relationship is you're dating and you're in different cities and you know that they're using, something that's classified as an illegal drug, but you're not doing it with them. And in fact, they honor your uh, desire to stay clean. That's going to be a facts and circumstance thing. But again, remember, there are two things we're looking at here. One is the drug use itself, but the other is your trustworthiness to hold a clearance. And if your association, and particularly a close and continuing relationship with someone who is at the federal level violating laws, a question is, can you be trusted with a clearance? Again, the answer is not necessarily an automatic no. If it's only marijuana, again, things may be changing. It is a different answer than whether you were using pot or other drugs. So that was a great question. Again, it comes down to facts and circumstances. Do we have other questions? Because right now we have no open questions. So I should have done more dancing and singing in the beginning. Let me hand it back to Kendall then. Oh, wait. We've got, okay, great. Someone just got their name in saying that they came in late, but you get the opportunity to ask anything about drug use and clearances. And actually, I will ask Kendall, can you answer the last question that came into the Q&A?
Absolutely. Yes, there will be a recording, and we'll put it up on our YouTube page. It usually takes about a week to get up. I will say, unfortunately, obviously, please watch the recordings if you want to learn more and share with your friends. Unfortunately, if you do not participate live, you won't receive attendance for that.
Oh, great. Oh, somebody asked a fantastic question, which I'm going to answer after this first question. One of the ones was, I did touch upon what about use before 18? And I kind of have two answers for that. One is uh, follow whatever the directions are on the SF-86. So sometimes the directions will say, have you uh, have you in the past 10 years after your 18th birthday done, and then they have like a checkbox quiz. So there are the directions explicit. Don't give your whole life story of what happened before you're 18. If it just says, have you in the past 18 years, remember, you're filling this out because you are a candidate for a job that will require a clearance, which means the agency, if you're getting a job directly with the federal government, or the contractor, if you're working for a contractor that is working for clearance, ask the security officer. Um, you don't want to make work for the investigators. If they don't care about what about before 18, you don't want to say, oh, yeah, which means they're kind of in a bind. Now they have to do it. But you also don't want to lie. You don't want to uh, 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 misrepresent your situation. So that's definitely one to check with the security officer. Uh, so now, one that's actually it's a great question, and it's one of the hardest things that I know I've come up against personally. And I'll give you the scenario that this person put in, which is my neighbor is a user. I know he has a clearance working for a contractor. Do I say something if I go for a clearance? And the reason why I say this is the hardest thing, the answer is you actually, especially if you have a clearance, you have an obligation to report. And that's really tough. Usually it's even tougher. It's my office mate is a user. So even a closer relationship than your neighbor, who maybe you have a close relationship with your neighbor, you have an obligation to report because you don't know what else is going on. And by the way, and you'll get training on this when you go through, presuming you do get a clearance, they'll talk about every year you'll take this mandatory training, and they go through the scenarios of, something is going on. And, they have the actors do the play acting and play it out. And sometimes it is someone's just having a rough time, and by reporting it, they get counseling and they keep their job and they live heavily after. Or, you report them and it turns out that they are being compromised, which means the national security of the United States is being compromised. And you may have just prevented, and they go through all of the famous security breaches. So unfortunately, the answer on that is yes, you have kind of an obligation to say something. So another good question is, your significant other is taking medication for psychological conditions. Is that a negative towards you? And then, a really good question. Are you considered a psychological risk by proxy? And this is one where I would counsel actually answer the question asked and only the question asked. Unless the question says, are you or anyone in your household, blah, blah, blah. You answer, do you take medication for this? No, I don't. Period. Now, if because there is the open door, is there anything we should know that might make you a risk for the US government? That's your opportunity to step in it, but it also means it's your opportunity to clear the air because, again, depending on the job, it's pretty likely the answer will be, we're not interested in your significant other, we're interested in you. But maybe this could avoid they do the investigation because, by the way, if you're going for the higher level clearances, they will literally knock on your neighbor's doors. And if the neighbors say, yeah, I always smell dope coming in over or whatever, uh, you're going to then like mysteriously not get your clearance. So that was actually a good question. And in fact, someone just asked, is there such a thing as being too honest on the form? Yes, there is such a thing as being too honest on the form. Don't make work for them. Answer the question that's asked. And if you feel there are things they should know or things that you think might bite you later, either put it on the form, definitely talk with your facility security officer. And also kind of depending what they say or depending how you feel, the very first thing an investigator will ask you when you get your in-person interview is there anything else that you've not put on this form that you'd like to tell me now? And that is, I wouldn't say a get out of jail free card, but that's when you can say, I forgot to put this down, or I wasn't sure about putting this down. Because again, if you don't say it and it was something that should have been there, it will be a problem for you. Another question is, so if you haven't done drugs, you shouldn't start now, which will guarantee it won't affect you when you apply for a job. Absolutely. If you've never done drugs, you don't have to worry about, you can just answer, in the past 10 years, I haven't. So that's yeah, I would not start now, even with the change of schedule. And by the way, more recent news in the 2023 National Defense Authorization Act, where the Senate passed an amendment to delist marijuana. Oh, good, I can start smoking marijuana. No, the House didn't adopt it. So, and again, if you start today, you're showing your willingness to violate federal law, which will not play well with your clearance process. This is one we got last year. It was a great head scratcher. Uh, and we came to a consensus. And it's, what about underage drinking? Isn't it illegal? Well, there are two parts of it. Isn't it illegal? So the first answer is, it's in most states, and this depends on the state, it's illegal to serve a minor. So the minor isn't the one violating the law. So that's thing number one. Uh, but what about if I made a fake ID to get into bars? Well, you're making a fake ID. So maybe you have stepped over the law. So facts and circumstance. If you know, drank once a quarter or once a month, uh, again, make sure that the question, for example, isn't under 18. Make sure it isn't something that happened more than 10 years ago. Uh, then it's going to be up. I'm not going to tell you don't put it down, uh, because if you were violating the law, there is that open-ended thing. Uh, But again, definitely talk to your facility security officer, to get their opinion in your circumstance. Uh, let's see. Let's see. Yeah, in fact, someone said, what if I only had a sip? That could make a great story. Again, I may have related back in the 1980s, talking to someone from a particular branch of the military. And someone had asked the recruiter, so this was when I was in high school, someone asked the recruiter about marijuana use, and this would go to like, what if I had a hit, or what if I had a sip of beer? And we were actually surprised, and of course, this was actually, I think it was just before marijuana got listed as Schedule 1. But so the answer may have been different. But the answer then was the head of that branch would rather have someone who like took a sip and didn't like it than someone who had never drank alcohol at all. Of course, he was talking about marijuana then, but we can substitute alcohol. And the reasoning was, well, if you tried it and didn't like it, you're probably not going to become an abuser, and you're probably a good choice to have a clearance. Whereas if you never tried it and then you do happen to try it and you go, wow, this is great. I love being stoned. I love being drunk. You'll be a big security risk. So again, a facts and circumstance. I think DEA might say, if you took a hit, you took a hit. But the other agencies probably say, why are you even bringing that up? Let's see. Uh, yeah, someone did ask, hey, does the government have, uh, Big Brother have the panopticon? How do they know that I've used illegal drugs? Um, Generally, again, depending on the level of clearance, certainly they'll know if you've been arrested. All public records are going to be open to them, which means if your roommate was arrested and said, yeah, I was, partying with Eric all the time, and that's in the public record, Eric's going to have a problem. If you're going for the higher level clearances, they're going to be talking to your neighbors. They're going to be talking to your family. They're going to be talking to your friends. They're going to be talking to your coworkers. Uh, so that's one way. And the other way is you're guaranteed to have a piss test before getting a clearance. That's a guarantee. And you may be subject, well, you are subject to random drug screenings. So that's what's going on. Again, I would not counsel for you to say, well, I don't think they're going to catch me with it, so I'll say no. Uh, if it's more than 10 years, follow directions in the SF-86. You don't have to declare it, but I can't say it enough times. Don't lie on your SF-86. And I can offer, if you are filling out the SF-86, and after a while, you're saying, you know what, I filled in 7 pages of, my misdeeds. Yeah, honestly, maybe a clearance isn't for you. Um, One question, focusing on, the topic for today, what if your family and friends really think marijuana ought to be legal? And right now it's illegal. Is that going to be taken into account for your clearance? Well, thing number one is the simple answer is no, clearly not. I would say if the thoughts and beliefs are we should do a violent overthrow of the US government, that might bring you in for more scrutiny. But look, the White House has some thoughts and beliefs about drug use. So, that's clearly fine. So that generally won't be taken into account. There are questions about terrorism and violent overthrow of the US government, that would be a thing that would be a consideration. Uh, Someone is asked, do I know about the personnel vetting questionnaire? Not yet. That those are things that are happening now as we do it. I can say the SF-86 used to be an awful Adobe Acrobat form, and then it became an awful web form. It is now a not so bad web form, but it's evolving. A really good question, would a lawyer be able to help fill out the form? There are many kinds of lawyers. The assumption here is, a lawyer who is involved with the clearance process, is, an expert in the clearance process. Absolutely. And that question comes into the last question I'll be able to answer today. It's actually one that's not quite on topic, but it does kind of hit on the drug use thing. The kind of question here, I'll do what the question is, and then I'll put it also into the context of drug use. What if you were misdiagnosed as psychotic, but it was proven later that you wasn't? Would that blacklist you as a candidate? And I can say answer number one, no. Facts and circumstance. You can demonstrate that it was a misdiagnosis, and so therefore give me the clearance. If you've reviewed from last year, I am personally involved with someone who weren't misdiagnosed. They had an event, they were misclassified, where they did do a hospital visit, and it was misclassified as an admission, not just as an outpatient for psychological issues. And their clearance was denied, and they said, because you were admitted to the hospital, they have employed a lawyer. The current status is they've put in all the paperwork, again, proving that you weren't, going back to that question, but they still don't have the clearance. And it's not clear that they will get the clearance. I'm rooting for them to get the clearance, but it's still an open question. So I don't want to get this particular person who asked the question, their hopes up. Oh, great, I've been cleared on the psychological thing. It means no problem with clearance. But I would also say, don't let that deter you from applying, because that alone should not disqualify you. So with that, that's the last question I have in here. And please don't type in another one because we are out of time. I'd like to hand it back over to Kendall for our end of webinar housekeeping.
I think that's it, Eric. Thank you so much for your time today. Really appreciate it. And thank you to all the students that joined us today. And we will see you in June. And again, if you guys have any questions, please never hesitate to reach out to me via email. I am always ready to answer any questions that you may have. Thanks again. Have a good day.
Thank you. Bye.